I think it is clear to believe in the power of ideas.
Fresh thinking to the Manhattan Institute.
The path to reform, which we're co-sponsoring with the U.S. Chamber of Commerce Institute for Legal Reform. Before I bring our presenter up, I would like to remind everyone to please turn off your cell phones and beepers so that you don't interrupt our speaker and our panelists this morning. It's been since April of last year when we first seriously held a conference in recent times addressing this issue. That was entitled Can Wall Street Stay on Top? And we focused on both the topic today, securities litigation, as well as regulation of corporations and securities in the wake of Sarbanes-Oxley. We had a good lunch and keynote speech from Deputy Treasury Secretary Bob Seale. That came in the wake of 3 different reports looking at U.S. capital markets competitiveness. The first in November, the loosely named Paulson Committee that was headed by our lunch and keynote speaker today, Professor Hal Scott. Then my former employer, McKinsey & Company, at the behest of Senator Schumer and Mayor Bloomberg, issued a report on the topic. And then finally, our co-sponsor today, the United States Chamber of Commerce, issued its Blue Ribbon Panel report on U.S. capital markets competitiveness. The president of the Institute for Legal Reform at the U.S. Chamber of Commerce, Lisa Rickard, came on board in March of 2003, just 1 month after I joined the Manhattan Institute. So I've been happy to work with her as a partner throughout my time at the Center for Legal Policy at MI. We've been working on this issue now for some 22 years, and I think we really paved a lot of the intellectual groundwork. We really laid a lot of the intellectual framework for this issue. But it was really 10 years ago when Tom Donahue at the U.S. Chamber came in and really got businesses seriously looking at this problem, looking at it intellectually, looking at it from a political standpoint, looking at who these judges were that the trial bar had long controlled, that you really saw a lot of serious positive movement at the national level on the issue. Those of you who read the New York Times, and I don't know how many remain as New York Times readers in this audience, but you may have seen Jonathan Glader's piece on the judicial election wars, of which our presenter today, Lisa Rickard, has been at the forefront from the business community standpoint, fighting not for the caricatured pro-business justices, but rather for justices that will fairly apply the rule of law, that will not make up new constitutional requirements and rights to defeat democratically enacted tort reforms, and they've been very successful in that endeavor. Under Lisa's leadership, the ILR has also really ratcheted up its intellectual efforts. We've been happy to partner with them in the past, and we're happy to partner with them today as they release their new study, Securities Class Action Litigation, the same title as our event today. I hope that after the event today, all of you will look at the study. It's a well of good insight into the securities class action litigation problem, and it has a wealth of good policy suggestions that I hope our leaders will take seriously. So I'd like to bring Lisa forward. I'm going to dispense from a lengthy introduction because her bio is in your packet. Rest assured that she's been a leader before she got to the U.S. Chamber, both in corporate America and in private practice, and on Capitol Hill for both parties. So she's well-schooled in law, in politics, and in business, and I'm happy to have her here to present the Chamber's findings. Let's give her a round welcome.
Thank you, Jim, for that very nice introduction. And I have been in all of those sectors, but I started when I was 12. Beautiful building. Thank you to all of you for coming out on this dreary day. We're thrilled to be here. As Jim mentioned, this year the U.S. Chamber Institute for Legal Reform celebrated our 10th anniversary. And while that milestone gave us an opportunity to look back at how far we've come in improving America's legal climate, it also allowed us to look ahead to see how far we've yet to go. As we demonstrate in the white paper we're releasing today, fixing our dysfunctional securities class action system is one area where the finish line remains a distant yet achievable goal. This report looks at the flaws in the system, building on the work of the 3 previous independent commissions that Jim spoke of, and combines it with an examination of the fraud and abuse endemic in the plaintiff's bar, and offers specific solutions to address both concerns. Simply put, America's securities class action system is broken, both in its design and in its application. The system poses a serious threat to the health of U.S. businesses, the prosperity of American families, and the strength of our nation's global competitiveness. If that weren't bad enough, it's also a system often subject to extortion and abuse, as we've recently seen in the indictments and jailing of some of America's most prominent securities plaintiffs' lawyers. Today, I'll take a few minutes, more than a few minutes, to lay out the nature of the problem, its impact on shareholders, the business community, and our economy overall. And then I'll outline very broadly some potential reforms that will help to improve the system. The theory behind securities class action lawsuits, protecting investors from abuse, has a laudable objective. Yet today, the system is out of control, logically flawed, and betrays the very people that it's designed to protect. Securities class action filings now represent about 1/2 of all federal class actions in the United States. And since 1996, 41% of all the companies listed on the 3 major exchanges have been named as defendants in cases. Last year, we saw the filings of new lawsuits increase 58% from 2006. And in the first half of this year, there's been a 60% increase compared to the first half of 2007. And there's a new development that should send shudders around the world. It seems that U.S. lawyers are no longer content with just suing American companies. In 2007, we witnessed a 73% increase in 1 year in filings against companies headquartered outside of the United States. Securities class actions are growing not only in number, but in size. Businesses in 2007 saw their market capitalization plummet by a combined $151 billion the day after they were sued. This figure is nearly double that of the year before. I want to point out that these enormous financial losses occur when lawsuits are filed, not when the lawsuits are concluded. This means that even when lawsuits lack merit, the target company faces a very stark choice. On the one hand, it could settle the case for millions or sometimes billions of dollars. On the other, it could fight it out in court, inevitably diverting the time and attention of management and racking up mammoth legal bills, all the while running the risk of incurring a potentially catastrophic judgment. Research conducted by Professor Anjan Thacker estimated that between 1995 and 2005, securities class action litigation caused the destruction of nearly $25 billion of shareholder wealth. So how does the system go from protecting investor wealth to destroying it? The answers lie in the very nature of the system itself. First, settlement payments in securities class actions are not financed by the wrongdoers, but rather by innocent investors. This is the most fundamental flaw in the current system. It's inherently circular. Securities class actions do little more than shift money from one investor to another investor. The circularity of the system stems from the fact that the defendant company, not the individuals guilty of wrongdoing, almost always pays the settlement. On average, individuals accused of wrongdoing contribute less than 0.5% of the typical settlement. The rest of the bill is footed by the current shareholders of the company. In addition to financing the settlement, existing stockholders also pay the company's defense fees, often 25 to 30% of the settlement amount. They also cover the inevitable increase in the company's insurance premiums. So who does benefit? Well, besides the plaintiff's lawyers, who I'll get to in a moment, most monetary gains are reaped by the investors who sold their stock at an inflated price while the fraud was ongoing. But while they profited from the fraud, they are not compelled to return their gains because generally they were merely blameless beneficiaries. Therefore, one group of innocent shareholders, those who hold the stock at the time of the judgment or settlement, ends up paying another group of innocent shareholders, those who are in the litigation class. Beyond this senseless circularity, private securities class actions don't provide adequate compensation to those investors who actually may have been harmed. This is the second fundamental flaw in the system. Indeed, once settlements are negotiated, injured investors usually recover only a tiny fraction of their alleged losses, averaging pennies on the dollar. The rest is siphoned off to pay transaction costs to plaintiffs' lawyers and other middlemen. Studies indicate that plaintiffs' lawyers typically take approximately 33 cents of the average settlement dollar, pocketing nearly $17 billion over the last decade alone. Now let's take a look at the third inherent flaw in the system. That is, small individual investors are the least likely to receive fair compensation from a class action settlement. Their recovery is dwarfed by large institutional investors who are as likely to derive benefit from selling stock at fraud-inflated prices as they are to suffer harm from buying and holding stocks at these prices. With lawyers reaping millions and investors collecting pennies on the dollar, the unavoidable conclusion is that private securities class actions do not serve the goal of compensating the innocent victims of fraud. The current system is also flawed in that it fails to achieve the other primary objectives, that of deterrence. Those who engage in fraud are already subject to ample regulatory, civil, and criminal enforcement powers. These powers effectively deter wrongdoers without the tremendous costs of private class action litigation. Public enforcement is on the rise at the Securities and Exchange Commission. Last year, the SEC brought more than 650 enforcement actions, a 14% increase over 2006. And over the past 4 fiscal years, it obtained orders for almost $5 billion in disgorgement and penalties from securities law violations. Through the SEC's Fair Funds system, injured investors can be compensated after the Commission properly identifies eligible beneficiaries and accurately calculates their shares of the fund. And unlike plaintiffs' lawyers, the SEC does not skim off 1/3 of recoveries in attorney's fees, meaning it pursues cases based on the merits rather than in search of a payday. As opposed to the private securities class action lawsuit system, public enforcement bodies can hold individuals who engage in fraud criminally liable for their actions. As we noted in the white paper, since 2002, the Justice Department's Corporate Fraud Task Force has obtained nearly 1,300 guilty pleas and convictions, including those of over 200 CEOs, and has levied billions of dollars in fines and damages on individuals. So unlike private enforcement, where individuals who contribute to wrongdoing rarely suffer much out-of-pocket expense, public enforcement provides deterrence through the threat of massive individual penalties, career-ending sanctions, and imprisonment. The truth that securities plaintiffs' lawyers don't want the public to know is that their cases often follow on the heels of government enforcement actions and do not truly serve their stated purposes of compensation and deterrence. The SEC, the Department of Justice, their state counterparts, and others are able to more efficiently prosecute wrongdoing, more thoroughly compensate shareholders, and more effectively hold individuals accountable for their actions. So as a result of our broken securities class action system, U.S. companies are taking a hit. Employees with retirement accounts invested in their companies are taking a hit. Average small investors are taking a hit. And finally, the competitiveness of the U.S. capital markets is taking a very big hit. The Institute for Legal Reform is obviously not alone in reaching these conclusions, as Jim spoke about earlier. Over the past few years, several other studies of the U.S. capital markets have identified securities class actions as a problem in need of immediate attention from lawmakers and regulators. For instance, the recent report by the Committee on Capital Markets Regulation, directed by our luncheon speaker, Hal Scott, and co-chaired by Glenn Hubbard and John Thornton, concluded that the modern securities class action lawsuit creates a heavy burden for public companies without a substantial social benefit. Their report recommended a number of legislative fixes to promote fairness in the system. A 2007 report commissioned by Mayor Bloomberg and Senator Schumer found that meritless securities lawsuits and settlements are driving up costs of business and driving away potential investors. The report called on Congress to bolster America's long-term competitiveness by enacting legislative reforms to securities laws. Another 2007 report, this one from an independent bipartisan commission established by the U.S. Chamber of Commerce, observed that the unique size and scale of securities class action damages impacts a company's decision to participate in the U.S. capital markets. It concluded that the significant costs imposed by the heavily litigious environment are disproportionate to its benefit. Finally, last November, the Financial Services Roundtable's Blueprint for Competitiveness offered strong recommendations on the problems facing our capital markets. Of particular note was their analysis and recommendations on securities class action litigation. Each of these four reports concluded that securities class action lawsuits hurt the competitiveness of the U.S. capital markets. There is no doubt that the ability to bring broad securities class actions in the United States has become a factor in a foreign company's decision to list or trade in this country. In fact, a 2007 Financial Services Forum study found that 9 out of every 10 foreign companies it surveyed that delisted from the U.S. exchange in the last 4 years, they did it in part because of our litigation environment. If foreign companies have an impression that the U.S. legal system is hostile, that's because it is. Earlier, I mentioned the increase in U.S.-based securities class action filings against foreign companies. Foreign issuers have been the targets of enormous settlements. In 2006, 13 foreign issuers settled securities class actions for a total of $2.4 billion, and 2 of the top 10 largest settlements of all time involve foreign issuers. In addition, there's been an upsurge in the filing of securities class actions on behalf of foreign plaintiffs against foreign companies for trading on foreign exchanges, referred to as F-cubed cases. There's a dispute as to whether jurisdiction in the U.S. is even appropriate in an F-cubed case. Regardless, the negative effect on the willingness of companies to list their shares on the U.S. capital markets is very clear. However, foreign companies are not the only ones delisting from the U.S. or choosing to go elsewhere. U.S. companies are doing the same. The percentage of U.S. companies going public overseas without also listing at home has jumped from less than 1% a decade ago to over 9% today. It's clear the United States is no longer the only game in town. Unfortunately, those pushing our economy to the edge of the cliff by extorting U.S. companies are some of the most powerful and wealthy plaintiffs' lawyers in America. And the problem goes beyond just a handful of bad actors. Securities class actions present businesses with a classic lose-lose dilemma. After weighing the cost to the stock price, company reputation, and litigation expenses in defending against a securities lawsuit, most businesses decide it's less costly to settle even the most baseless claim. Plaintiffs' lawyers know this. In light of the overwhelming pressure on companies to settle, it comes as no surprise that settlement costs have increased dramatically. The total value of securities class action settlements in 2007 climbed to nearly 15 times the total in 1998. In 2006, settlements amounted to an unprecedented $17.6 billion, and 9 of the 10 largest securities class action settlements of all time have occurred in the last 3 years. Again, the first 6 months of 2008 have continued this growing trend, producing 2 mega settlements that totaled more than $1.5 billion. The abuse of the securities class action industry is systemic and is fueled by another disturbing trend, referred to as pay-to-play. Over the past few years, a pay-to-play culture has emerged in which plaintiffs' law firms contribute to the political campaigns of elected officials who control the appointments to boards of public pension funds. The public pension funds have assumed an increasingly important role as lead plaintiffs in securities cases. Therefore, having connections to board members increases the likelihood that a plaintiff's firm will be appointed as lead counsel in these lucrative cases. Thus, the firms who pay are selected by the pension fund officials to play, thereby setting up a self-reinforcing system of mutual back-scratching. The pay-to-play phenomenon has been documented. A USA Today investigation found that in 5 states and 2 major cities, trial lawyers who had given large campaign contributions to politicians were the ones chosen to represent pension funds in securities lawsuits. While pay-to-play abuses are clearly unethical to the outside observer, they are at the core of the culture of greed and corruption that helps spawn a new class of criminals. Instead of working to protect the average shareholder, the system has been hijacked by a group of trial lawyers who are using it for personal profit and breaking the law in the process. As you all know, the most obvious and far-reaching scandal involves the preeminent plaintiffs' firm of Milberg Weiss. Over the past year, we've seen 4 of its former partners convicted of paying more than $251 million in illegal kickbacks to so-called professional plaintiffs, which allowed the firm to beat everyone else in the race to the courthouse. Some in the plaintiffs' bar contend that providing kickbacks to lead plaintiffs is a victimless crime because the kickbacks are paid out of the lawyers' contingency fees. Yet recent empirical evidence by law professor Michael Perino suggests that Milberg Weiss did not pay for kickbacks out of its own coffers. Rather, it dipped into the settlement pool by charging higher rates to its clients. In other words, the firm amassed hundreds of millions of dollars by essentially taking money from its clients' pockets and giving it to itself. Not only is the scope of this 25-year criminal scheme staggering, so is the disclosure by former Milberg partner Bill LaRock that the illegal conduct of paying bounties to class action plaintiffs was merely industry practice. Although Congress enacted the PSLRA in 1995 to clean up abuses like paying plaintiffs illegal kickbacks, LaRock admitted that these criminal actions were not only continuing, but are systemic within the trial bar. Shouldn't we take Bill LaRock at his word and investigate the admitted systemic and fundamental flaws in the trial bar? Unfortunately, while the U.S. House and Senate leadership has been eager to conduct oversight hearings into the perceived abuses of a host of other industries, it's been silent on this issue. ILR has been urging Congress to investigate the Milberg-Weiss scandal and LaRock's claims so that our civil justice system returns to aiding people who've been wronged, not helping wealthy trial lawyers become wealthier. These efforts have been getting some traction. Earlier this year, Senator John Cornyn introduced the Securities, Litigation, Attorney Accountability and Transparency Act. We have to think of a new name for that bill. His bill and the companion legislation sponsored in the House by Representative Jeb Hensarling would halt some of the questionable activities practiced by securities class action lawyers. The chorus calling for congressional oversight is growing. Both House Republican leader John Boehner and House Judiciary Committee ranking member Lamar Smith have called for hearings to expose the trial bar's abusive and fraudulent practices. The underlying culture of greed and corruption uncovered by the Milberg-Weiss scandal demonstrates that the current system is both broken and subject to ongoing abuse by those who know how to scam the process, namely the trial lawyers who today continue to control securities class actions. Common sense reform measures should and must be enacted by Congress if we're going to clean up trial lawyer abuses and keep our nation on a prosperous and competitive course. For the next few minutes, I'd like to present some of the most crucial reforms detailed in ILR's white paper. Cheryl Evans, ILR Special Counsel, is going to take a more detailed look at some of the proposed reform during the panel discussion. First, we suggest coordinating the SEC fair funds with settlement recoveries in private class actions. A second recommendation is to provide for an immediate appeal of the denial of a defendant's motion to dismiss a case. Our white paper also recommends the sharing of discovery costs, which would curb the abuse of the discovery mechanism. And the report requests that Congress modify the existing rules on civil discovery to curtail excessive discovery, including permitting the cost of discovery to be shifted from defendants to plaintiffs when discovery requests are unjustified. We propose numerous other fixes as well, including those that would close the loopholes that weaken previous congressional reforms, preserve the efficiencies of the current widespread use of arbitration, increase transparency into the settlement process to allow analysis of which investors actually benefit from these cases, and refine how damages are measured and how money is distributed in order to ensure that the system operates in a more clear and equitable manner. However, reform is meaningless if the culture of greed and corruption pervading the securities class action system is allowed to persist. And so we call for Congress to pass the Securities Litigation Attorney Accountability and Transparency Act, championed by Senator Cornyn and Congressman Hensarling, as a way to address these broad concerns. This measure would cast sunlight onto the relationships between attorneys and plaintiffs, as well as eliminate pay-to-play conflicts and other suspicious connections between attorneys and elected officials. The legislation would also introduce a competitive bidding process for the selection of lead counsel and call for further investigation into the hourly fees paid to plaintiffs' attorneys in securities class action litigation. Let me close by making one thing clear. The current system of checks developed by Congress is not sufficient. We believe our suggested reform measures should be enacted in order to fix the broken, wasteful, and duplicative securities class action system. Now is the time for Congress to act. The cost of continuing to ignore the growing threat imposed by the securities class action system is simply too great for shareholders, our economy, and our capital markets to bear. Thank you very much for your time.
If everyone could, I guess, quickly take a break and then quickly return to your seats. I want to try to keep us on schedule because we've got a tight time frame, and I want everyone to have a chance to ask our panelists questions after they comment on Lisa's remarks and on this excellent Institute for Legal Reform study. So thank you again, Lisa, for a very comprehensive, I think, look at the question of securities litigation. We've got with us today 4 panelists, each of whom are going to bring a different perspective to this question. I'm going to go in reverse order from how they'll be speaking. First, Cheryl Evans, Lisa's colleague, is a special counsel at the Institute for Legal Reform at the U.S. Chamber of Commerce. She focuses particularly on this issue and on securities, corporate governance, capital markets, the criminalization of corporate conduct types of issues there, and she's been instrumental in drafting this report. And I think it's going to give us a lot more insight into the policy proposals Lisa just briefly outlined. Secondly, we've got Adam Pritchard, who's a professor of law at the University of Michigan. He's one of the foremost academic scholars looking at securities litigation from an empirical and a theoretical standpoint. So he's going to give us his thoughts. Then we have, from the corporate sector, Alyssa Kelman, who is at J.P. Morgan Chase. And so she can give us a lot of insight into how corporations really are affected with securities litigation, particularly in the discovery process. And then finally, we're going to hear, it's going to be first, but finally I would like to introduce Andy Pincus, who's a partner at Mayer Brown Law Firm, one of the foremost appellate litigators in the country, and he's going to give us the perspective of a lawyer in private practice. So starting with Andy, let's hear each of our panelists briefly comment, and then we'll have some discussion and open for questions. Thank you.
Thank you, whoever applauded. Very, very much. Thanks, Jim. I thought I would pick up for some further comment the portion of Lisa's remarks that dealt with this question of abuse and what's going on sort of on the ground today in securities litigation, because I think it really gets to a fundamental question that underlies much of the debate about securities class actions, which is, are these suits generated by plaintiffs who are seeking to recover for damages, sort of the paradigm that one learns in law school? Lawsuits are for people who feel wronged to vindicate their rights. Or are they really just of, by, and for plaintiffs' lawyers, with the plaintiffs just there as an afterthought? Congress first looked at this question in a pretty comprehensive way in the 1990s during the series of hearings and discussions that led up to the Private Securities Litigation Reform Act, which was enacted in 1995. And there, one of the clear findings that underlie a number of provisions of that law was that, in fact, these were lawsuits that were controlled entirely by lawyers, and plaintiffs were a total afterthought. And in fact, Bill LaRocque's famous remark at that time that he had the greatest law practice in the world because he had no clients sort of was the emblematic of what Congress found to be the state of affairs. And as a result, it tried to address this problem by giving more control to actual plaintiffs and taking control away from lawyers. And that hasn't really worked for two reasons. One is, as you heard, there have been just out-and-out violations of law, violations of the provisions that Congress enacted. But more fundamentally, plaintiffs' lawyers are a very entrepreneurial group of people. Sometimes you wish that they were using their entrepreneurial spirits for something maybe that would be more productive for our economy, but very entrepreneurial and have really found a way around those protections in a fundamental way. And let me talk a little bit about those two situations. The violations I don't have to discuss very much. Lisa talked about, and you're all probably very familiar with the Milberg-Weiss situation, which is just a clear, long time, stretching into the period after the PSLRA was enacted, violations of law that not only involved the use of payments to get plaintiffs, but really a pretty, as a lawyer, shocking scheme where the principal expert witness, a guy named Torkelson, who sort of created the damages model that Milberg-Weiss used in its cases, was presented in court as someone being paid on an hourly rate, but who actually was being paid on a contingent basis based on whether or not Milberg-Weiss won the lawsuit. And there were a whole series of under-the-table payments, pretty remarkable additional problem with what was going on in those lawsuits. But the reform that the PSLRA tried to initiate was to say, well, individual plaintiffs are shareholders who hold a couple hundred shares in a company are not going to take control of a class action lawsuit and take on the burden that entails. But we have institutional investors in the marketplace. Maybe they're the people who can help provide plaintiff control over lawyers. And so a process was established for identifying a lead plaintiff based on a large number of shares in comparison to the other members of the plaintiff class. And as Lisa said, the plaintiff's lawyers very skillfully have gotten around this by essentially co-opting institutional investors, principally public pension funds, and creating a relationship where, yes, it's true, the public pension funds are the named plaintiff, but we're back in a situation where the litigation is really being controlled by the lawyers. And I commend to you all the USA Today survey article on this and other articles that are cited in the ILR report, because it's really quite interesting. You wonder, why are these New York lawyers contributing to state treasurer races in Louisiana and Ohio and other places? It just seems odd until you realize that under those states' law, those are the officials that have control over either directly over the pension funds or either the boards of the pension funds. And then things become a little clearer. But it's not just the political contributions. The Chicago Tribune did a piece that found that the outside lawyer who acted as a general counsel to a pension fund got a payment of $750,000 in connection with a fund in which that pension fund was the lead plaintiff. Now, the pension fund's total claimed loss was $225,000. So the question the Tribune was asking was this payment sort of a payment for delivering a lead plaintiff? Because to the Milberg-Weiss, or I actually don't recall the law firm that was the principal law firm there, the total fees were $44 million. So obviously very lucrative to get that pension fund to select that law firm as the lead lawyer for the case. There are other stories that talk about swaps of legal services. A pension fund says, gee, we need some legal services in this other corporate or litigation area. Maybe we can create an arrangement where we'll pick you to be our lawyer and we'll act as lead plaintiff in a case if you give us free legal services in this other area where we need help. And then there are very interesting stories picking up on Lisa's mention of Europe, where a recent story in the legal press involving a dispute between a law firm and some prospectors that it had hired to deliver large shareholders in Europe as prospective plaintiffs in cases. And as with all contractual agreements that break up, some very interesting discussion of the share of the profits from the lawsuits that the prospectors would get if they were able to deliver somebody who could act as a lead plaintiff. But especially interesting are the admissions of some of the people at the public pension funds who have participated in these cases. And I won't talk about them all, but the general counsel of a Florida board said, we didn't choose the lawyers, they chose us. Another former director of a Philadelphia pension board said, the truth is there was just a bounty hunter prowling the securities industries, picking things and putting our names on it. So any illusion that the system Congress devises work is sort of blown up by those kinds of admissions. We're back to a world where the plaintiffs' lawyers are controlling the system. And let me just give two more examples, because they really just happened this past week. Reports of judges in the Southern District getting very angry at plaintiffs' law firms who were trying to manipulate, in one instance, the size of the claim of their client in the litigation in order to get lead plaintiff status. And Judge Rakoff said, A, we probably have a problem with that, and B, I talked to the guy who was the head of this pension fund, and he knew nothing about the lawsuit, had no idea what was going on, and was clearly just there as a straw person for the lawyers, and therefore I'm not going to allow those people to be the lead plaintiff in this case. And then another case where a law firm had a long-standing case pending against AIG and thought it would be a very good idea if it could smuggle in all the allegations relating to subprime and therefore obviously create a much bigger damages pool in its case. And there Judge Sprizzo said, I'm not going to allow this to do. This is just a fishing expedition by lawyers trying to expand the pot, and we're not going to allow that to happen. So some judges are taking action. The problem is they really don't have the tools to do it. Why is this important? Because lawyer control means that the kinds of economic issues that really raise questions about whether this litigation makes sense for shareholders don't get raised. The lawyers don't care about circularity. They're not the people who are the owners of the company that are shouldering the costs of the litigation and the ultimate settlement. But a real shareholder would have those concerns and therefore might decide that it doesn't make sense to bring the suit in the first place. So all of those considerations go out the window when it's just the lawyers in control, as do considerations about fees. Lisa talked about the huge amounts of money that are now at stake in these cases. As someone who's been active in this area for a long time, if you haven't been involved in securities litigation for 10 years, just take all the M's for millions and put in a B for billions. I mean, it is literally tens of billions of dollars of settlements, and you can do the math on what the attorney's fees. There's a lot of money at issue, and the studies indicate the hourly rate is huge. And so if you're the lawyer and you can control the litigation, that your focus is going to be on getting those fees. And the evidence is that's what's happening. The report talks about some judges that have tried to rein in fees. But as any judge you talk to will tell you, and Judge Walker, who's a judge in California who's tried to do something about this, will say, after the case settles, there's no one giving an adversary presentation on whether the fees are excessive. The defendants all want the case to go away. They've signed off. The fees don't come out of their hide, they come out of the settlement, so they're not interested. So you're a district judge with your 2 or 3 law clerks with a big pile of timesheets trying to figure out whether all of the hours that were incurred are legitimate or not, and there's no way to do that. And so we have a situation where there's no control on fees, huge amounts of money, and obviously plaintiffs' lawyers who are trying to exploit it. Finally, just to pick up on the last question, which is a lot of people have said about this system, well, maybe it doesn't matter. These people are acting as private attorneys general. We need somebody to step in, even if the lawyers really are in control. Who cares? Because they're doing good. And I think that's the key point of in the report and what Lisa said. They're really not. If you think about deterrence, and many of you probably are involved with companies, paying a big class action settlement is not a badge of infamy in corporate America. Everybody thinks it's a price of doing business. All the cases that get past the motion to dismiss stage settle, so it's not as if some company that has to pay the money is later going to be thought to have engaged in illicit conduct. That's what comes from enforcement actions. What people really don't want is an enforcement action from the SEC or a criminal action by the Justice Department. That's the threat that's deterring wrongdoing, not a big check where everybody does it and everybody just views it as a cost of doing business. And second, we now have a world where, unlike 20 years ago, the SEC has the power, if it's appropriate, to get compensation for investors. And so in that world, given the abuses that we have, you really have to question whether this whole system makes sense. Thanks.
Morning, everybody. I mean, obviously, people have made some really excellent points here today already. And speaking, thank you. Speaking as an in-house lawyer for a corporation, I certainly can say I've seen a lot of the sorts of abuses and concerns that people have raised here today, and particularly in this economic environment. Lisa mentioned the white paper indicates that securities class action filings in the first half of '08 increased nearly 60% from the first half of '07. I know that I and my colleagues sort of in January just got slammed by a wave of new lawsuits. And it shows that bad economic times lead to lawsuits. And even though there have been some important Supreme Court decisions that limit pleading standards, it doesn't seem to make a difference. It seems that any time there's any kind of economic disappointment, any kind of earnings disappointment, any kind of bad publicity, you'll have a lawsuit. I mean, we sort of joke that whenever we do an acquisition, we're going to have the lawsuit that says we paid too much and the lawsuit that says the target received too little. And then we'll have the ERISA lawsuit and the shareholder derivative lawsuit, and there'll be 6 or 7 or 8 different lawsuits about this one transaction. The white paper indicates that at the current rate, the number of new securities class action lawsuits will top 200 by year's end. And, you know, maybe we're just a defendant in all of them. Sometimes that's how it feels, because that actually sounds low to me. In terms of discovery, we expect this year to initiate new discovery holds in probably twice that number of lawsuits. Now, those won't all be securities class action lawsuits. In fact, most of them will not. But our general findings are that more than half of our new discovery holds relate to our investment banking business. And sort of just anecdotal evidence, we find we hold between 10 and 50 mailboxes of employees, sometimes for a year, sometimes for more. Each month is a separate collection effort and a separate cost to us, and then separate work by the law firms to review it, and then not to mention all the other computer-generated data that we need to look for. And I was actually sort of struck the other day. I got an email on the search results of a pretty small, very, very targeted search just across 5 boxes. And they came back and they said, well, we've got 1,100 unique emails. And my first reaction was, well, that's nothing, 1,100 emails. It's like a joke. But the truth is it's not a joke, because the cost of even reviewing those 11,000 emails is probably $20,000 to $40,000. And there's other things we could be doing with that $20,000 to $40,000, right? We could put it towards the salary of a new teller, and then y'all, when you go to the bank, don't have to wait in line for so long. So to the extent that the paper, for example, says that $25 billion in shareholder wealth was wiped out, well, that's $25 billion that could be going back into investing in the business of these companies. And the burden of this preservation and the cost of the preservation and of reviewing it is really not understood at all by judges or the plaintiffs. One of my favorite stories is I got a non-party subpoena asking for all documents relating to, let's call it Acme Corporation. And I called the plaintiff's firm and I said, look, you gotta give me a hint. You know, what kind of transaction? When was it? What part of the bank was it? Who worked on it? And the response I got back was, well, can't you just run Acme on the computer? No, because we don't have like a magic computer that goes through all of our hundreds of subsidiaries and all of our hundreds of offices all over the world. And so people really don't understand, and judges don't really understand, and I do think that's part of the problem. And I think that a greater scrutiny of securities lawsuits in particular prior to discovery is appropriate, because unlike the normal commercial transaction where you and I engage in a business deal, and I do something to you, and you think that what I did was bad, and so you sue me. That's not what happens here. There is no specific conduct that the plaintiffs experience that they're reacting to. What they're reacting to is the mere fact of an earnings disappointment or some other negative publicity, and the stock price goes down. And most of the time, that's really all they have. And then everything after that is sort of a fishing expedition to see if, in fact, that was just bad luck, bad business, or was something more culpable. So they're really seeking to turn these unsuccessful business strategies into fraud. And for that reason, I think it's particularly important that the complaints be tested thoroughly for sufficiency before discovery is allowed to proceed. One of the white paper recommendations is the right of appeal from denials of motions to dismiss or summary judgment. And that is a right the plaintiffs have. If their case is dismissed, they can bring an appeal. But if we lose a motion to dismiss, that's not considered a final judgment on the merits. And we can't. And I really think that not only should we have that right of interlocutory appeal, but that the discovery stay should stay in place. New York state courts do that, actually. They allow interlocutory appeal, and it's discretionary with the judge as to whether the discovery stay will stay in place. And I'll be honest, more often than not, they decide it doesn't. But those courts function fine. It's not an insuperable burden for the appellate courts to test these complaints before asking us to spend hundreds of thousands, if not millions of dollars in discovery on a case that's really just triggered by a bad earnings report. Another thing the white paper talks about is exceptions to the PSLRA stay on discovery, which we've seen in several contexts, permitting third-party discovery, asking people to turn over what they gave to the government, or permitting discovery as to non-moving defendants. And I think all of those are bad ideas, but I'll particularly mention the third-party discovery because that really makes me crazy. Because the argument is that if you're not using the defendant's resources, so who are you hurting? Well, you're hurting the non-party. And if you haven't tested the complaint to see that it has merit, then there is even less reason to go to some stranger to the transaction and say, give us all your documents, than there is to go to the party. And I believe that financial institutions probably are more burdened by this than other companies, but I will tell you that in 2007, we received in excess of 24,000 non-party subpoenas. Now, most of those were not in securities lawsuits, but that's a tremendous drain on our resources to respond to 27,000 non-party subpoenas. So we think that discovery stays are important, and then again, going back to another one of the white paper's recommendations is cost shifting. Personally, I think that in every case, judges should contemplate cost sharing because the plaintiffs have no incentive not to file these lawsuits other than their manpower limitations. They have no documents. Maybe the plaintiffs have this many documents showing they bought the shares. They don't have any witnesses other than the class rep. So there's really no incentive for them to be rational and measured in what they ask for. And the plaintiffs' firms, as you've heard, reap enormous financial benefits from these cases. Lisa and Andy both discussed that the firms were paid about $17 billion in the past decade. So if they really believe that these cases have merit, it's certainly appropriate to ask them to make an investment in determining whether those cases have merit. And I promise you, if they do, at the end of the day, they'll be able to make an application to the court for reimbursement of those fees. But we certainly have cases where they file a lawsuit, they do some discovery, and then they say, well, do you want to make a corporate governance change? And we know that they don't really believe that anything terrible has happened. And the reality is, as Andy said, that these cases are plaintiffs driven. These people have lists of investments held by plaintiffs they've dealt with before. They decide it's time to sue Acme Corporation. They go down the list. They say, okay, John. They call John. And I'm not saying that John never independently evaluates whether he believes that that case is meritorious or not. I'm sure that sometimes they do. And I'm sure that sometimes they don't. And certainly when you hear that some plaintiffs have been plaintiffs in 60 or 70 lawsuits, I don't know how many individual stocks you all own, I don't know how many stocks you have to own to really believe that 60 or 70 of the companies in which you own stock committed securities fraud. So I think it's clear that the system is still broken. And although there have been efforts in the past few years, there have been some good Supreme Court decisions, this is something that needs to be focused on and needs to be addressed. Because the cost of these cases really is disproportionate. And again, every dollar we spend on litigation is a dollar we can't put back into the business to hopefully make better returns for our shareholders. So thank you for your time.
The speakers that have come before me have had a chance to detail for you a number of the abuses that relate to securities class actions, and I don't really disagree with anything that they have said. I want to focus instead on what I consider to be the root of the problem. And I'm not sure that I'm allowed to say this in New York, but the root of all evil is money. In securities class actions, the problem is the money. The regime we have sets up a big pot of gold, and there's $1 billion, or maybe there's $2 billion in this pot of gold, and people are going to do what they can to get their hands on that piece of $1 billion, and the company that has that piece of $1 billion is going to be willing to pay something to not have to give it up, even if they think the suit is totally frivolous, right? If there's a 5% chance that you're going to have to pay out a $2 billion judgment, then you should pay $100 million to make that lawsuit go away. There is money to be made on lawsuits that have little or no merit. So why is there this $1 billion pot of damages waiting for the plaintiff's lawyer who's skilled or lucky enough to collect it? Well, the basic problem, and I use the word basic advisedly, is a Supreme Court case called Basic versus Levinson, which basically, I gotta stop doing that, which misunderstood the purpose of a private cause of action for securities fraud. Private cause of action for securities fraud has two purposes. One is to deprive wrongdoers of any benefit they might have gained from the fraud, right? We want fraud to not pay. The other is to protect investments in information. If I am collecting information about a company, trying to analyze it, figure out how much it is worth, we want to protect those investments so that I'll continue to make them. That's how the price discovery process works in the securities market, and we want to protect those investments. The fraud on the market regime that we have does not require any investment in information. We excuse reliance in fraud on the market cases. We say that you relied on the market, which is to say you didn't collect information at all, right? You just bought at the price because you figured the price was reasonable. It also does not deprive the defendant of the benefit of his wrongdoing, right? We take the money away from the corporation. Corporations don't defraud people. People defraud people, right? There's a corporate executive who has made that misstatement because he wants his stock options to be in the money, or because he thinks if he doesn't make this quarter's earnings, he's going to get fired, or he wants his bonus to be greater, right? There is money to be made from fraud, but it is made by the corporate executives who engage in it. So, but we have a regime where the defendant is not, the primary defendant, the corporation has not benefited the fraud, but is on the hook for potentially billions of dollars worth of damages. So that's kind of senseless. It undermines the purpose of the secure private cause of action. But it's worse than that, right? Because it undermines deterrence, right? We think fraud is bad and we would like to discourage people from engaging in fraud. But the regime we have targets exactly the wrong companies, all right? If you wanted to predict who's going to be sued in a securities fraud class action next week, next month, your best place to start in making that prediction would be to look at market capitalization, large companies, And then the next thing you'd want to put into your formula for predicting would be who has a volatile stock price, who's going to have a large stock price drop. All right? You haven't explained all of the variation in the incidence of securities fraud lawsuits, but that's a good place to start. The next thing you want to throw in, well, they announced a restatement. All right? We're done now. Big company, large stock price drop, they had a restatement. I know that they're going to be sued, right? I've got the data, I can show you that that's what's going to happen. That is the company that doesn't need to be sued, right? That's the company that analysts are following. That's the company that got hammered when they restated their earnings. That's the company where the chief financial officer is going to get fired, right? So, and it's probably the company that the SEC is taking a long, hard look at. We're throwing all of these enforcement resources at it, and well, as long as we're at it, why don't we have a securities class action as well? So deterrence is not working if that's where we're targeting securities class actions. So that's all very depressing. I'm usually very depressing at events like this. I say it's really bad. But today I have a proposal to fix the problem. I have the fix. And the fix is, it turns out, to be simpler than I thought, right? I've been working on these issues since 1996. I helped write the SEC's report on private securities litigation reform back when I was a very junior lawyer. And, difficult issues, all of the abuses identified by Lisa and Alyssa and Andy. But I think that we need to undo BASIC. So we can undo BASIC by persuading the Supreme Court that they got it wrong. That seems very unlikely to me. As far as I can tell, they have no idea what they're doing in securities law cases. We could persuade Congress to fix the problem. They were asked to do that in 1995 by no less than Chris Cox. Chris Cox wanted to undo the Basic versus Levinson presumption. That quickly went by the wayside. Congress had the chance. I don't expect them to fix the problem anytime soon. The SEC, they could potentially fix it. Chris Cox, you'd think he would fix it, but I believe he's too busy running for governor to actually do anything about securities class actions. So all I got left is the shareholders. The shareholders can potentially fix this. And the reason is the basic problem, Basic versus Levinson, is not a requirement of the securities laws. It's a procedural shortcut that the Supreme Court adopted to make securities class actions more manageable. It can be waived. Shareholders of the corporation can waive compensatory damages, pay me my out-of-pocket losses in fraud on the market cases. They can waive that in the Articles of Incorporation, so it would no longer be reasonable to rely and to collect the compensatory damages. The proposal I have in mind is an amendment to the Articles of Incorporation which would limit compensatory damages to cases of actual reliance. For the Rule 10b-5 suits, the 80% of the suits that involve trading among shareholders. Joe trades with Jane, Joe has a windfall gain, Jane has a windfall loss. Waive the damages for that unless you can show that you read the company's misstatement. You read the financial statement and you relied on it and that's why it was purchased. We should compensate those people. That is a very small group of investors. In its stead, the damages formula could be, in this proposal, I think we can do this in the Articles of Incorporation, would be make the wrongdoers give it back, right? So the wrongdoer cashed in stock options that were inflated by the fraud that he's responsible for, make him give that back. I think we can do that through the Articles of Incorporation. So the benefits I see are sanctioning wrongdoers. That's good for fraud deterrence. Bringing down the level of damages from a level where you must pay if the lawsuit gets past a motion to dismiss, or you are betting the company on the hindsight of a jury. So instead of $2 billion being on the table, do you want to settle or do you want to go to trial, maybe it's $5 million on the table or $10 million. you litigate that. If you think you have a good case, you go to a jury with that, instead of we're going to pay because there's a 5% probability that we've got to pay $2 billion in damages. Because this is a judge-made remedy, right, it only applies to Rule 10b-5 actions, causes of action, my proposal. So it only covers about 80% of the securities class action mess. There's the public offering suits where the companies actually benefited from the fraud, right? They misstated their financials and were able to collect more money in their public offering. It wouldn't fix that. So I'm only fixing 80% of the problem. Poor Alyssa is still going to have a problem because she's got all those public offering suits, and I can't help her. I feel bad, but I can't help her. But I've got something that I think can fix 80% of the problem.
Good morning. I think it's still morning. Pleased to be here. Well, I feel like I don't have much to say. I think Adam has fixed most everything, so perhaps I'll just say a few words and sit down. Lisa's highlighted some of the abuses, and I'll be going over those. Excuse me. I had a little trepidation about following Adam. I've heard him speak before, and he's very entertaining, and I started to think, what can I do that would sort of, be a good follow-on? I started thinking of, could I have a pile of money here, or something that I could do that would be more entertaining, but I'm sorry to say that I couldn't really come up with any gimmicks, so I'm going to just sort of highlight the things in our report, the potential reforms, and sort of go through them and sort of tell you why we think they matter. I think Lisa did a good job of highlighting those. We believe that the potential reforms, fall into a variety of categories, and they do, in fact, I think, address the majority of the issues that we highlight in our report, so we tried to match them up fairly well. We are optimistic that some of these can be done in a bipartisan way, as the PSLRA and SALUSA were done in that way. Although Adam's solution is certainly interesting and worthy of consideration, and he's been talking about it for a little while now, and so we would really urge people to sort of think about this notion and this fix that he's come up with. The reforms that we have put forth fall into categories that include fixes or reforms that serve to address some of the abuses in this area, address some of the inefficiencies in the system, take away some of the pressure to settle even non-meritorious cases, as everyone was discussing here today, including creating more fairness in appellant procedures, closing some of the loopholes in the procedural rules that govern the cases, and preserving the current arbitration system, which we think should be highlighted. I'll mention that in a moment. Although that doesn't directly go to our paper, it's a really significant issue, I believe, and we've been thinking about this and focusing on this in a variety of fronts. And also fixes that would lead to insight, as Lisa mentioned, into the settlement process. There's really not a lot of transparency into the settlement process right now, and we had worked with and spoken with a group of law professors from around the country, and that includes Adam, and that was something they were concerned with in the past. And still are, I'm quite sure, in refining how damages are calculated, and that's a fairly convoluted process, but we think that maybe it could be simplified or made more fair. And then, of course, taking into account SEC fair funds. The SEC has this new authority in the last 4 or 5 years, and they have been doing a fairly good job of getting money back to investors, and I'll talk a little about that for a moment. I'm going to try to get through as many as I can. It's fairly lengthy, but we'll highlight a lot of those. Many have been highlighted already. Obviously, we suggest the enactment of the Securities Litigation Attorney Accountability and Transparency Act, which I'm calling SLATA, which is a shortened version, although not the most catchy version. And this was introduced in both the House and Senate. And in general, this legislation was intended to promote, as the name would suggest, both accountability and transparency with respect to the conduct of attorneys in securities litigation in order to provide innocent shareholders who ultimately bear the burden of abusive and wasteful litigation. And we think these safeguards make sense. They're fairly simple and straightforward and could be, if it was focused upon, enacted on a bipartisan basis. As we've noted, it requires enhanced disclosure of payments, contributions, and other potential conflicts between attorneys and plaintiffs, and that goes to really the two issues that we've talked about here today in that area, which are abuses, Milberg-Weiss-like abuses, which would be payments to plaintiffs, and sort of taking control of the cases. Clearly, we're concerned by Bill Lorac's statement that this is industry practice, and that this point would also address some of the pay-to-play issues, because parties would be certifying that they did not receive payments, compensation was not involved in the selection of lead counsel. So we think that's important. We've noted that Jack Coffey and the Committee on Capital Markets Regulation have highlighted the need for curbing pay-to-play practices, and we think this is significant. Also, it would, of course, allow for competitive bidding so that to really ensure that shareholders aren't charged excessive fees and are represented by counsel who will serve the interest of all class members. So that's significant as well. And then we think the competition may stem some of the high hourly rates in these cases. Our study points out that at least over a period of time, some of the average fees were over $1,350 an hour for attorneys in these cases. And lastly, the legislation calls for the study of attorney fee awards, requiring a GAO study of the average hourly rate, and looking into that issue. The white paper highlights some specific abuses in this area. And I think when you think about this, sort of left to wonder whether the fees are warranted in many cases, especially those when the class counsel merely files after the SEC has acted, or just based upon a drop in stock price, really having done little work. So are they earning the $1,300 an hour? And that's certainly something to be considered. And as Andy mentioned, a lot of judges aren't really looking into the fees. They just kind of want the case to go away at the end of the case, and sort of no one's really taking a close look at how fees are structured and what payments are being made. And then along the same lines, we suggest improving accuracy in the selection of lead plaintiffs. We believe that Congress should require the submission of detailed documentation and verification of putative lead plaintiffs' alleged losses to prevent attorneys from inflating some of the numbers to obtain appointment as lead counsel, and we provide some examples in the paper of when that was done. Under the PSLRA, the presumptive lead plaintiff is the largest plaintiff that has the largest financial interest. It's supposed to be the most adequate plaintiff. And we've seen some examples of judges sanctioning parties, or counsel rather, for really exaggerating or just outright making up the losses of their clients. So that's something that we think needs to be looked at and addressed. And then as Alyssa mentioned, we're suggesting limiting discovery and really, I guess I wouldn't say really limiting, it's shifting the costs of discovery in these cases, although I think limitations may be warranted as well. But we really focus on the cost shifting. Alyssa did an excellent job of providing concrete example of what's happening in this area. And discovery clearly can be used as a very large gavel or hammer hanging over the heads of corporations. And in some instances, the mere cost of discovery is really the reason that companies are settling. Just that alone is a rationale for settlement in some of these large cases when you could have 1 million email messages or something of that nature. And this issue was highlighted by the Supreme Court in the Stone Ridge decision. The court noted, I'm just going to quote, "Extensive discovery and the potential for uncertainty and disruption in a lawsuit allows plaintiffs with weak claims to extort settlements from innocent shareholders." And that's something that we have seen empirically to be the case. And certainly the ever-increasing volume of electronic discovery makes this more important. So we're suggesting Congress allow for limited cost shifting when a requested discovery is not directly relevant to any of the specific claims or defenses in the case, and that could be done by amending Federal Rule of Civil Procedure 26B. And as we've touched upon already, we're also suggesting that Congress provide equal access to interlocutory appeals, specifically allowing defendants to appeal the denial of motions to dismiss. We believe that the existing system is really fundamentally imbalanced. Securities class action plaintiffs may immediately appeal a trial court's decision to grant a defendant's motion to dismiss, but defendants don't have the equivalent right when there's a denial of their motion to dismiss. I'm sorry, it should really have been the plaintiff's decision regarding summary judgment. But in any case, there's not the commensurate right on each side. One side can appeal and the others cannot. And that's significant, and that is really a pivotal point in the case, and we believe that right should be there for defendants, as it is in most every other kind of case. And we also highlight that virtually all of these cases settle. And we note and believe that the immediate appeal of these judgments on motions to dismiss would provide broader benefits to the securities industry and to the system by enhancing the likelihood of obtaining really valuable precedent-setting judgments and develop some law in this area where there really is none because everyone is settling and there's really no law on the motion to dismiss issue, which really goes to the merits of the case. And we suggest refining the measure of damages in securities class actions. And I should note that I'm not an expert on damages, but I'll do my best to kind of highlight what we have in the report. We have 3 or 4 general recommendations. Overall, most damage models involve a principle of aggregate damages, which requires imprecise estimates of the number of shares purchased during the class period, really at a supposedly inflated price, and then subsequently held or sold at a lower price after the discovery of the alleged fraud. We have noted and heard and read that broad, sort of vague methodologies in calculating damage really encourage huge claims and create sort of perverse incentives in this area, and we believe exacerbate the fundamental circularity inherent in the problem. So we think a variety of reform measures could make the system more fair and ultimately better serve investors. And the first damage remedy change that we propose, which is significant, is that Congress could cap liability in securities class actions to shift the focus from the defendant's to the defendant's alleged gain to the plaintiff's alleged losses. So essentially, right now, we're looking at plaintiffs' alleged losses, and how they're calculated is all kind of mysterious. And of course, plaintiffs try and extend the class period to make it sort of fit so they have the largest loss. And so we think it makes more sense when you have a system that isn't really working well and isn't really compensating those it was intended to compensate, to really pull back, and possibly focus on the defendant's gain. And that would be a very new system, and that's something we think should be considered. And caps on liability overall have been proposed by a variety of professors in this area, those who write and speak frequently on this topic, Professor Langebort, Coffey, and Alexander, and others, and we have a variety of examples in our paper on that point. We also suggest the possibility of offsetting, that Congress could require the calculation of damages to be offset by the net gains of class members who sold shares prior to disclosure of fraud, and thus benefit from the artificially high price. And this offsetting would be a new sort of a new way to look at damages, but it's certainly a sort of common sense approach. And this also ties into the circularity issue. And then we suggest the possibility of a per-share calculation, that Congress could require that damages be calculated on a per-share basis, equivalent to the number of shareholders who actually submitted valid claims. And you would think that's done now, but that really isn't in place at this time. And this has been suggested by former SEC chief economist Ken Lane, who's now a professor at Pitt, and he's been writing and talking about this point for quite a while, and had a piece in the Wall Street Journal that mentioned that as well. And along the same lines, we're asking for, as Lisa and others mentioned, transparency into the settlement process. There really is a lack of sunlight into how settlements work, how the money is distributed, how lists of plaintiffs are compiled, and really just kind of how this works. So we're asking for Congress to eliminate some of the murkiness in this process and require filing of public reports describing the claims filed and what was paid and how that worked, without, of course, disclosing names of plaintiffs. And we think that may shed some light on whether this is working, because frankly, a number of professors have said, we don't know how this works. We don't even know if it's working at all. And as I mentioned at the outset, we suggest maintaining the efficiency of the current securities arbitration system, and that's I think, important to note here in this context. The widespread use of fair and what appears to be timely and efficient arbitration procedures in handling securities disputes through the securities industry, through FINRA now, which was the NASD and NYSE's regulatory bodies, we think should be preserved. We think it works well. Studies have shown that it works well. The Inspector General did a study of the SEC's Inspector General did a study and concluded that it was effective and efficient. Michael Perino, who was mentioned earlier today, did a similar study and noted that the empirical evidence suggests that SRO, self-regulatory organization arbitrations, work well and are fair to investors. We've seen think it's important to us because we've seen arbitration right now in the last 6 months or so, maybe even a year, under attack in a variety of venues on Capitol Hill for a variety of types of cases, and really across the board attacks on pulling back on arbitration. And ILR has released a study several years ago that it was a survey, and we gathered information and really highlighted the fact that people believe that arbitration is simpler, fairer, and faster, and works well on balance. And in particular, the securities industry arbitration is being looked at by SROs, by FINRA, so they're kind of looking over the shoulder of the arbitrators and analyzing that. And we suggest fair funds and class action coordination. As Lisa mentioned, that Sarbanes-Oxley authorized the SEC to order that any disgorgement and civil penalties that they obtain from a defendant in securities enforcement action may be labeled a fair fund, marshaled together, and given back to investors. And they've been working hard to do that. In our paper, we note that at least 115, and probably more by now, fair funds have been created, and $8.4 billion have been recovered and given back to investors. Actually, I guess about half of that has already been distributed, maybe more based on the SEC's own reports. And the fundamental notion behind this is that the SEC, we believe, can do a better job at getting money back to investors without the added cut of attorney's fees, without the abuse that we're seeing in the system. And we think that there needs to be a coordination so we don't have duplicative recoveries as well, because that could certainly happen and would really just be another tax on business that doesn't seem to make sense. And then lastly, we suggest a variety of procedural changes that are highlighted in the paper that we believe are necessary to ensure that the system operates in a fair manner and as intended, things that would sort of fill in what's happening with the PSLRA, where plaintiffs' counsel would have found ways to get around some of the PSLRA requirements, and a lot of these are outlined. I'll just note a few of them. I guess the first, we suggest that the number of times a plaintiff may amend a complaint, and this is fairly straightforward, should be limited. We're seeing what people are referring to as repleadings, where companies are able to, or plaintiffs rather, are coming back, and once something's dismissed, saying, well, we're going to write another form, maybe we can come at this another way, and companies are having to come back again and again. And so we think that is not sensible, and there should be some limitations on that. We also, of course, suggest reversing the expansion of the exceptions to the PSLRA stays on discovery and making stays mandated and required in these cases. It really doesn't make sense for discovery to go forward when you have a motion to dismiss pending, and we think basic fairness warrants that. And one of the other fixes, there are 5 or 6 in here, is that Congress should reform the opt-out suits in state court. Plaintiffs' lawyers have, in some instances, circumvented the PSLRA and SALUSA by encouraging pension funds with large claims to opt out of class actions and file non-class cases in state court. And these opt-out suits really burden investors and impose costs on 2 levels of the judiciary, and also threaten to possibly have inconsistent rulings. So we think that Congress should either preclude opt-outs or require a stay of opt-out suits until the federal suit moves forward, the class action. You can look through some of the other procedural reforms if those are of interest to you and you practice in this area. I guess overall, as Lisa noted, we believe that these common sense reforms will serve the best interest of shareholders and help to improve the structure of class actions and ensure the health and competitiveness of our capital markets, which are clearly under attack right now, and we need to do whatever we can to bolster them. Thank you very much.
Well, I'd like to thank all our panelists. I certainly have a lot of questions, but I want to get our audience the ability to ask questions. We've got a lot of sophisticated folks here in the audience. I think we've got, a pretty broad consensus up here that our class action securities litigation system isn't meeting its theoretical mandates, the notions of deterrence or compensation or what you want to talk about with it, that huge costs are imposed on companies, including third parties, through the discovery process, that there are problems with who selects the lawyers, who controls the lawyers, how do we pay the lawyers, and all these policy discussions, policy suggestions we've had have been designed to fix that. So I'd like to open it. Please wait till I recognize you and until you get a microphone if you have a question. Yes, there in the back. And please identify yourself.
Steve Hockman, I'm a mediator and do a lot of class action mediations. I wanted to ask a question, maybe to mainly Alyssa and others. The use of the derivative claim that is asserted in state court against the directors, for example, the one I'm most familiar with is one that was brought on behalf of Citigroup against all of the directors for being responsible, allegedly, for the WorldCom and Enron debacles that cost the company billions of dollars, okay? And these talk about bogus claims. I mean, this was a case where basically the plaintiff said we had all this discovery, we couldn't find any director who was personally involved because directors don't do that. Directors only hire officers who may or may not do that, okay? And, but nevertheless, and this was a criticism I had of Citigroup's board, they basically paid ransom to the plaintiff's lawyers. I remember the hourly rate for their fee request was $1,250 an hour for all kinds of low-level people that they put on these cases. Clearly a bogus case. And the only benefit to the corporation, I put that in quotes, was corporate governance improvements that had already been announced for public other reasons. It was absolutely bogus, and there was one brave judge in New York, Charles Ramos, who, because somebody objected, happened to be me, by the way, and said, don't approve this settlement. There was another objector who thought the fee was too high. I said, don't approve the settlement. And 9 out of 10 odds, they'll just go away empty-handed. Now, the settlement that the board agreed to was give the lawyers $3.5 million, okay? And what we're going to get are releases to basically exonerate all the directors, including the one director who might have been involved, who happened to be the CEO, and they were willing to pay ransom. And I said to the Citigroup lawyers, why are you doing this? You're going to encourage more of these hold-up ransom cases. In fact, there was a copycat case by Travelers very shortly thereafter, and there's been others. My question to you, Alyssa, if a derivative action was brought against your institution alleging that the directors were liable for something that some of your officers did, would you basically pay ransom, or would you say, millions for defense, not 1 cent for tribute, we have to send a message, and as far as I know, the only judge who was brave enough to do, basically disapprove the settlement, and Citigroup saved $3.5 million. They haven't offered me anything. Not that I was looking for it, but it was a matter of principle.
All right, I think we've got the question. Alyssa?
Okay. Well, if it makes you feel any better, we got the same lawsuit. We moved to dismiss it. The dismissal was granted. It's now on appeal to the Second Circuit. We expect it to be argued in September. So, keep your fingers crossed that it will be affirmed on appeal. I mean, the truth is, the calculus of when you pay a settlement, and I can't say that we always feel much more positively about it than you do, but the question is, how much money are you going to pay to defend these lawsuits versus how much money you can pay to settle them? And it's a difficult challenge. It's a difficult balancing act. We've tended to be aggressive with these cases. We have had plaintiffs file shareholder derivative suits and call a week later and say, so are you interested in corporate governance? And no, we're not. But I can't criticize other people for making different choices, because these cases can last for years. They are a huge drain. They're a drain on the directors. They're a drain on management. it's not a good choice to have to make.
I mean, I think it's important to realize that businesses are acting rationally in what they perceive to be their self-interest, and it's really the rules that create this enormous pressure to settle. Some of the reforms Cheryl was talking about that the Chamber is supporting are designed specifically to address this problem. If, in fact, you could shift onerous discovery costs onto the plaintiff's attorneys, that would change the calculus. If, in fact, you could appeal from a denial of a motion to dismiss, that would dramatically change the calculus, and you'd go forward with the litigation. But when you don't have that ability, the cost of defending the suit itself is really high. I think that the WorldCom Citigroup litigation is interesting. In a parallel case, I think it exemplifies the pay-to-play problem with the pension funds that we discussed. And I've written on this. Alan Hevesy got control of the litigation on behalf of the New York pension funds, gave the litigation to law firms that had donated generously to his campaign when he was New York Comptroller. And what was interesting is that the New York pension funds were suing Citigroup over the WorldCom incident when in fact they owned a heck of a lot more stock in Citigroup than they had ever owned in WorldCom. So it shows just how perverse some of this is and why the pension funds in particular aren't necessarily going to be acting in the best interests of the actual pensioners themselves, but rather in the political interests of the individuals controlling them. I think we'll have one more question. Roger, if we could bring... Yeah, that'd be great, so we can get you on tape.
This question comes from the point of view of just a small stockholder. As sympathetic as I am to the problem of mismanagement being alleged to be fraud so that you can bring one of these class actions. There are some of us who actually own stock in companies, JP Morgan and other financial institutions. And what may not be fraud, but has been, as we watch the subprime crisis and the capital markets crisis unwind, there's been an amazing amount of incompetence, greed, and utter stupidity in the financial companies that have lost billions and billions of dollars for their stockholders. So although, on the one hand, I don't think we're probably not talking about fraud, I think Professor Pritchard is the only one of you who's kind of onto something with respect to how do you deal with the corporate governance system that we have doesn't seem to get enough bad managers fired and enough people who are overpaid incompetence to be relieved. And I think that's, that problem is manifesting itself in class actions, which really shouldn't be the right solution, and aren't the right solution, because you're just punishing the stockholders further. But I guess what I'm asking is, what is the right solution? And if Professor Pritchard or the rest of you have
any thoughts, Professor, or anyone else?
I will say one of the reassuring trends in corporate governance from the perspective of the small investor is the rate of firing for CEOs has gone way up. The trend of the last 10 years is that boards much more likely to fire underperforming, incompetent CEOs. And the cleanest, most effective remedy for bad management is a good firing. So part of the goal ought to be is a corporate governance system that puts authority in the hands of independent directors who are very actively engaged in monitoring the CEO. That is a difficult task, but we've made progress. It's a lot better than it was 10, 15 years ago. I'm sorry? No, they go downhill rapidly, to be honest with you. The rate, now you're testing my memory, the rate was maybe 1 or 2% of CEOs getting fired, and it's now more like 4 or 5%, I want to say, which if you're a CEO, you don't sleep as well at night.
And it's also, I think, a complicated situation. I mean, I worry about what are we going to do outside the securities litigation arena. I think that the criminal sanctions that were mentioned earlier are disturbing in some respects. I mean, part of what we've been talking about is, are we over-criminalizing this? Are we going to over-regulate this? My colleague, Nicole Gelinas at City Journal, wrote an article and is working on a book on criminalizing capitalism, and she thinks we really need to reorient the small individual investor and put our regulations more with respect to those individuals, because that's who people really get upset about. It's when the person has the entire pension in Enron and then Enron disappears. And while we certainly don't want to dictate what individual investors do, if we could reorient, say, the tax-exempt retirement accounts, the 401ks, the IRAs, and have some neutral, minimal diversification requirements, the individual investor would be somewhat protected. The current system, if it's not actually deterring fraud, and I think we've heard a lot of evidence that it's not, is merely taking money out of the system, paying off lawyers, and shifting it from one class of shareholders to another. If you're a diversified investor, all you're doing is paying into the system. You don't really care because you're equally likely to be a payor or a payee in the current system, depending on when you bought stock in the company that's getting sued. So the money really is circulating, and the system really doesn't work well. But I think we have to worry a lot about overreaction. The one thing I think that's abundantly clear is that neither the securities litigation system nor the new onerous requirements that were regulatory brought in under Sarbanes-Oxley prevented this debacle with a subprime mortgage situation. That should give us all pause and really lead us to think, what are the systemic risks we want to be regulating, and what really should the individual shareholder protection be? Because the current system's not doing a good job of protecting the individual shareholder, nor really should it be. But for smaller, less sophisticated investors, if they're diversified, they're going to be protected in the long run. I'd like to thank everyone for coming and our panelists. And if everyone could move out those doors in the back, they've got to come back in here and reset for lunch, and we'll come back and hear Professor Scott. Thanks.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.